Welcome to Transnational Competition Law course and dear learner and viewer, as we have discussed during the last week and the previous lecture about the embarrassment of extraterritorial application of competition law, and we have also devoted to many lectures on the topic of enforcement of extraterritorial application of competition law in continuation to the embarrassment of extraterritorial application of competition law and the enforcement of extraterritorial application of competition law. Now we are going to discuss with you the extraterritorial application of competition remedies. One of the questions which is directly involved with the enforcement of the extraterritorial application of competition law is that what is the nature of enforcement, what is the reach of the enforcement, what are the different kinds and classification of enforcement, and how the competition law tries to address the question of the victims of the market abuse of dominance, anti-competitive practices, regulation of combination, merger and amalgamations, and predatory prices, bid rigging, and price fixing, and the issues of cartelization. The basic purpose of any law is to see that it is not observed in breach, but the success of the laws lies in the fact that it has been complied and the level of compliance are more and the deviances of the laws are less. From that standpoint of view, dear learner, the study of the competition remedies is something very important to our understanding in the course on the transnational application or transnational competition law course which we are undergoing. First thing first, dear learner, we will try to understand as to what we exactly wanted to convey and make you to understand by saying competition remedies. As we know that following a violation of the competition law, the competition remedies essentially results in some kind of the legal battle and litigational strategy, be that at the level of the agreement among the parties or be that at the level of the national competition authorities or by any competent court of law for redressal of the grievances and an amicable settlement and to have some kind of the remedial justice. It is in fact the entire nature of the competition remedies is to see the therapeutic perception of the competition law enforcement and justice. How the competition law authorities, tribunals, and the courts are going to decide and deliver judgment which can satisfy all the parties to a particular competition dispute. In this respect, as we have noted in the previous lecture, that the competition law in particular and on commercial law in general happens to be resolved through mediation, consultation, arbitration, good offices, and a series of negotiations. Here we wanted to see that the very nature of the competition remedies essentially results first in the negotiation between the interested parties, and then the competition agencies try to look at the very purpose of the competition law as well as the purpose of the basic objective of the competition law, endeavors to avoid the blockage of a merger or the enforcement so that some necessary steps following the violation of competition law are to be redressed immediately in an expeditious and a timely framework. In this respect, what we find that the nature of competition remedies, after having a very critical scrutiny and a study of the competition agencies and their published guidelines, manuals, and all substantive procedures which have been laid down by different competition law agencies and authorities, the one point happens to be very specific, and that point is the broad policy and guiding consideration in the competition disputes, which encompasses a variety of factors. And it is in that context very essential for our understanding to look at those principles and guiding considerations which generally visit and revisit in all kinds of competition disputes and try to set the nature, course, and direction of the competition remedies. If you look from that point of view as to what happens to be the broad principles and guiding considerations of the competition remedies, we find a large number of remedies, but for our ready reckoning and understanding, we have culled out few remedies which happens to be, or the few problems which happens to a direct bearing on all kinds of competition remedies in matters of enforcement of extraterritorial application of competition law and as well as in the transnational competition disputes and transnational competition law. The first and foremost problem we find in matters of competition remedies pertains to that the remedies of the competition should directly address to the question that where the agency can establish a concern to the competition, meaning thereby the entire thrust of the remedies depends heavily on the kinds of forum, the kinds of agencies, and kinds of authorities the competition institute of a particular country or a regional competition protocol recommendations and conventions and guidelines, or for that matter, the international competition soft law documents try to envisage and perceive that what can be the forum convenience and what can be the forum non-convenience. So that is first and the foremost issue in understanding the nature of competition remedies. Then the other important segment of the nature of the competition remedy is the fact that all the competition remedies must be restorative in character, meaning thereby that it should best on the doctrine of restitution. When we try to understand the nature of the competition remedies, the second important segment of the remedies happens to encounter the problem of the ambit and scope of the competition remedies. And in that respect, it is generally said that the remedies of the competition dispute must completely preserve or restore competition. That is the basic and obvious and ostensible purpose of the competition law. But at the same time, it must restore the parties to the original position. And in that respect, we can say that the competition remedies must be restorative in character and based on the precept of doctrine of restitution. The other problem which encounter in matters of competition remedies pertains to that these remedies be least restrictive in nature, and overall the focus of the competition remedies is to effectively eliminate the competition or anti-competitive conduct and the behavior. So the entire remedial measures of the competition law at one hand try to restore the competition in the market, and on the other hand happens to effectively eliminate all extraneous considerations and factors which try to impinge on the elimination of the competition, be that the abuse of dominance, anti competitive behavior, or any kind of the predatory pricing. The competition remedies should also address two major competition concerns, and it should not be used a kind of an offshoot for the industrial planning, or the competition remedies while advancing to the satisfaction of the parties should not read into the boundaries of non-competition purposes. Here it is very important to understand that the nature of the competition remedies should be strictly within the doctrinaire limits of the competition purposes at and, and at no point of time the nature of competition remedies have a tendency to encroach upon the non-competition purposes. The last concern which we can address in the nature of the competition remedies, that remedies should not be ideal and utopian in character. Rather, it should be practical and implementable on the ground. So, this is one of the very essential characteristics and nature of the competition remedies. Besides being practical and implementable in character, it should also be delivered in a very time bound and expeditious manner, and the issue of the enforceability of the competition remedies should always be taken into consideration, that it does not require a very stupendous methodology and executory mechanism to see actually that the competition remedies reaches ultimately to the doors of the parties and the victims of the market. Dear learner, while taking into consideration the nature of the competition remedies and trying to blueprint as to what can be the kinds or classification or the focus and the objective of the competition remedies ought to have visit in all competition law authority, agencies, tribunals, and courts of justice and law, we will be concluding that point that the basic ethos of the competition remedies is to see that the non compliance of parties of the competition remedies should also be dealt with a very heavy hand, and any kind of remedies which has been handed down by the competition agencies or tribunal or the competent court of law should also try to follow up as to whether these competition remedies which has been rendered in a particular competition dispute are actually going to be executed in letter and spirit, and the non-compliance of the competition remedies should attract the condemnation of the law with some very punitive action, fines, imprisonment, so that the advancing of the competition remedies and the decision about the competition remedies should observed in compliance of the law, not for the breach of law, and a kind of a deterrent mechanism of the compliance of the competition remedies needs to be established to have a very salutary impact in eliminating all anti competitive behavior and in enhancing and restoring the competition in the market. Having understood the nature of the competition remedies, dear learner, we will try to understand the kinds of the competition remedies, the shapes and color and hues of the competition remedies. It is under this context, dear learner, we will look at in a very broad sense as how many categories of the competition remedies can be made out, and then what we see that there are two kinds of the remedies. The one happens to be the structural remedies, another happens to be the behavioral remedies, and sometime you may say as third, but it appears to be the second kind of the remedy, which is called as the behavioral remedies, that is also known as the conduct remedies. Noting down that there are two broad kinds of remedies, competition remedies, we will try to see that what is the basic tenets of the structural remedies. Structural remedies or structural competition remedies usually include divestitures of the assets, while the behavioral remedies can include commitments to provide certain services or goods under specified conditions or a renewed condition de novo or in a fresh manner. It can also try to deal in a non-discriminatory manner, and it also avoids bundling of the product to maintain certain level of the prices. The distinction of the structural remedies and the behavioral remedies will be deciphered, but let's understand as to what exactly structural competition remedies try to see is a kind of the process of divesting the entire assets of a particular firm which happens to indulge into some kind of the anti-competitive conduct having far-reaching ramifications on the market. In that context, what we find, on the other hand, the behavioral remedies are characterized by an ongoing interventions in the market, and therefore the behavioral remedies are considered by the competition agency as less desirable than that of the structural remedies. They are also very more difficult to enforce because to understand exactly and to locate and underline as to what behavioral dimension of the competition law have been investigated and established beyond reasonable doubt, and unless and until there is a foolproof mechanism of investigation of the behaviors of the firms in the market, advancing of the behavioral competition remedies become very difficult for the enforcement. Thereby, what we see in matters of behavioral competition remedies, the competition agencies generally adopt a kind of a mechanism of wait and watch and see to apply its ruling only in those cases where they found that there is a prima facie and or a cogent evidence of behavior which has a cascading effect into the market. With this, what we find that behavioral remedies of the competition include the restorative practices of certain goods and services. It also sets new terms and conditions. It also tries to look at the discriminatory and non-discriminatory manner, how we can maintain the level of the price in the market. And the distinction between the structural competition remedies and the behavioral competition remedies needs to be understood very carefully, because in the embarrassment and the enforcement of the extraterritorial application of competition law, we have to see that which remedies suits under what circumstances and what can be the appropriate occasion for the administrative expediencies of the competition law to apply either or remedies, meaning thereby the structural remedies and the competition remedies. We have a case in point to buttress this argument in the sense, and the case number one happens to be in 2010 by United Nations Department of Justice reached a consent decree with Ticketmaster and Live Nations, which included the behavioral remedies and paved the way for the approval of their merger. As we have discussed that the behavioral competition remedy is an ongoing process, taking that ongoing and perpetual character of the behavioral remedies, meaning thereby the behavioral competition remedies are not one-time remedies, but it is a kind of an standing remedies, a perpetual remedies. The case in point of Department of Justice of United States in Ticketmaster and Live Nation's case, finally applied the behavioral remedies and paved the way for the approval of their merger. The other case in point to understand the structural and behavioral remedies is the case of 2020 by the European Commission, wherein the European Commission accepted commitment proposed by the Google in connection with its acquisition of the Fitbit, and it has imposed a series of behavioral remedies as a condition to the approval of the merger. So, in Google acquisition of Fitbit and the entire investigative process from the standpoint of the competition law enforcement and remedies, the European Court reached to the decision of making fresh conditions for the approval of the merger. Dear learner, having understood the nature of the competition remedies and kinds of the competition remedies, what we can safely conclude is the fact that the structural remedies are usually considered more effective because it has the tendency of correcting the market harm, and at the same time it try to restore competition in the market. Looking from that point of view, the structural competition remedies have a tendency of sustaining long-term competition in the market. The second advantage of the structural competition remedies happens to be the enforceability of the structural competition remedies, which are considered easy than that of the behavioral remedies, and the primary factor for considering the enforceability of the structural competition remedies as simple is attributed to the fact that their characteristic as one time in intervention in the market is something which can be easily applied, enforced and executed for the restoration of competition. On the other side, flip side, we see that the structural competition remedies are less vulnerable to creative interpretation and creative circumvention by the parties. So this is a very important point in adding some advantage and benefits to the structural competition remedies. The scope of the creative interpretations and creative circumvention by the parties happens to be the doors happens to be open wide. Nevertheless, the experience of many competition agencies have discerned that the structural remedies are difficult in matters of designing as to how and in what manner it can ensure maintenance or restoration of competition. And there, a degree of circumspection is to be exercised that while advancing structural competition remedies, how well we try to design and assure the maintenance and restoration of competition, and those conditionalities are to be well drafted and neatly carved out. That is why what we see that in the structural competition remedies, the parties are generally obligated to divest As we have mentioned that the structural competition remedies primarily include the divestitures of the assets, and in that respect, then the parties are obligated to divest, and it creates a, a large number of problems and difficulties that as to how we can find the acquirer, and then how assets are to be divested to an acquirer, and how it is not well suited to maintain meanwhile the level of the competition in the market. So at that stage we do find some very potential problem in the application of the structural competition remedies. But as a whole, taken as a whole, the experiences of the competition agencies in the enforcement of structural remedies is successful, but have some partial hiccups and hurdles in the implementation and the enforcement of the structural competition remedies in matters of finding it difficult to the entire divestiture procedure, and the asset acquisition sometimes assumes some problematic dimensions. With this, dear learner, I hope that today's discussion on the nature of competition remedies and the kinds of competition remedies to be applicable in the arena of extraterritorial application and transnational competition law will be very helpful to further our reading and understanding of the competition remedies for a very effective enforcement of the competition law. With this, I conclude and thank you, and I wish you a very happy learning and the browsing.